after some excellent feedback from a very small number of you, I think I've thought through a little bit better some of the ways that I can do this online and make it work for us all. So, just move that out of the way. So I'm going to make a couple of little changes. One of them, as it turns out, I was going to do differently this week anyway. I had no plan to have at the beginning of the class quiz, but the second half of the class, depending on how much work we've got to do or how much we've got through, we'll either do one big problem or a bit of a quiz with a series of little ones, or we might do both, just depending on how you feel. The big problem is actually, come on, is the ACE Cubbies problem, which is in Canvas for you to do as a kind of quiz, but I like doing it bit by bit so that we can, you know, answer the questions and then talk about the answers pretty much straight away. Also, the quiz is proving quizzes are proving a little unreliable. There seems to be a problem that appears to be on my end of the keyboard, and I've now had two people write to me separately in separate weeks and say, I answered this and I don't understand why I was wrong, and the reason for that was because they were right. So if you don't understand what the quiz has done, chances are it's because I've been a little quick when I've been checking boxes or something, when I've been transferring the quizzes from the way that we used to do them in a classroom into Canvas, which I was doing late last year. So another piece of feedback that I got is that it could be easier for people, I want to use the technical legal expression, dick around a little bit less, my words, not the respondents, if you knew where to find the quizzes in advance. So we're not going to get to them for a while, but I'm giving you this slide that you can see right now. And I think that these will remain open. So if you're watching in a recording, this should be open for about 7 days, and you can go and play along anyway if you want to with these two. Also, now you've got them. If you're bored, you could do these instead of listening to me. I'm also swapping my software over. I'm going to stop using Poll Everywhere, and I'm starting to use this one called Menti because it lets 50 or more people in, and also gives me a little bit more flexibility with the kind of questions I can ask. Again, rigid policy of absolute flexibility, changing a few things up. The other thing that I am going to do is set my timer here to make sure that I give you a break. I'm going to try for 2 quick breaks this time, because 3 hours is a bloody long time to sit in front of a computer. And the other thing that's clearly different from last time is you can now see each other if you put your videos on. So ideal position from my point of view is your mic is muted but your video is on, because that makes it a lot more pleasant for me, and I suspect for each other as well. But I get it that people don't always want to do that. If it's a bandwidth problem, absolutely. If it's not a bandwidth problem and you're just worried that I'm going to be looking at your clothes rack with your dirty underwear on it. See, why would you put your dirty underwear on the clothes rack? Surely it would be your clean underwear. But anyway, you could play around with the settings and you might find that you can actually surprise us all with a different background in Zoom, which is quite fun. So there you go. If you get bored, you can work out how to do that. Questions, concerns, frustrations? Okay, the other thing about changing this way is I've just got chat. I don't have the Q&A section as well, which I was finding that hard to moderate or to deal with last time. I'm not promising that I'm going to be any better today, but there's lots of moving parts. Let's do our best to make it work, hey? Okay, let us continue on. This little map that you can see in front of you is basically the second half. There's the first part of it. There's the whole thing. Sorry, I'm not looking at my slides, so I'm likely, if they move and it doesn't make sense, I will have hit a button. I'm looking at you, because if I do that, it's just going to be really embarrassing for us all, right? So, yeah, this is grid of, or I don't know if you call it an org chart, mind map, a kind of decision tree process for looking at consideration that we started with last week. And we basically focused on the two elements, the requirement for the benefit and detriment, and that linkage to a bargain. As you will find is the way with a great deal of the work that we do in law subjects, is we learn the rule by exploring the exceptions to it. And so now you've got the rule, what we're going to do is spend our time looking at these different exceptions, or different parts of the rule, and then the exceptions to them. But you'll feel like we're just looking at exceptions as we go through. So this part of the map is basically where we're focused on today. Some learning objectives in there. The reason these are important, and I must admit I tend to forget to put them in the slides, and I must get better at that, but a good place to look for them is in the topic notes that were so beautifully redone for you. I had a pretty good look at today's topic today, and I found 3 typos, and 1 unfinished sentence, including, I think in here somewhere, it said fresh consideration is required, and then there was an adverb or something, and I can't remember, but it's gone. So if you find ones that I don't know, I am still prepared to pay in chocolate. I will even pay the postage if that's what it comes down to. So Tiffany's winning at the moment, but I'm prepared to take advice on these documents from anybody, and this is a good place to look for them. Why am I mentioning it? Because clearly I'm just rambling on today. I'm going to stop that. Because when it comes to assessment tasks are designed to assess whether or not you met a learning objective or not. So they are actually a quite useful thing, particularly at the end when you're going back and preparing for the exam, to go back for each of the topics and have a look at what the learning objectives are, because that can help focus your attention on what it is that you should be learning. Make sense? So, first thing that we're going to... Sorry, Marius?
Where's the notes for this? I can't find it online. The notes you are sharing at the moment, where are they?
The slides, they were uploaded probably about an hour ago in the topic 5 slides and recordings.
Okay, thank you.
Okay, sorry, doesn't it tell you? I thought you automatically got pinged with a message when I uploaded things. I'm happy to send you an email, but I just feel like you're hearing from me 20 times a day sometimes. So, anyway. Okay, so past consideration. That's the first thing that I want to really focus on. Sorry, dog. I'm just going to send a message upstairs and say, please come down and sort something out. So, let's just start. Past consideration. Past consideration. Moving on. Here's the rule. Consideration can be executory or executed. As soon as you say executory, you want to change the emphasis on the syllables, don't you? It can be executory or executed, but it can't be passed. In other words, the consideration can be a promise that is not yet been fulfilled, executory. It can be executed, so it can happen absolutely in the moment that the contract is made, that split second when agreement is reached and payment is given. But it cannot be something that happened in the past. Now, when you think about this, it sounds tricky, but it doesn't actually really need to be, because effectively it's the same as saying that the consideration needs to be part of the bargain. So when we talked about woolen mills last week, one of the reasons why there was no contract in the woolen mills case was because the things that the Australian Woolen Mills Company did weren't as a consequence for or in response to as part of the bargain with the Commonwealth. They would have done those things anyway. So the key case here is Roscola and Thomas. I've just realised now I've brought up my slides without my notes. I might actually swap the packet in a minute just in case I get to a tricky case, but when I get to a tricky case I'll have a look. That was supposed to be a benefit for me of doing these from home. I could have my notes in front of me and I wasn't going to get the cases wrong. So Roscola and Thomas is yet another case about buying and selling a horse, where effectively what happened is, I'm going to need to remember, I'm guessing it was probably Thomas sold, see this is what I need my notes for, Thomas sold the horse to Roscola, and Roscola says, afterwards, says, is it a good horse? And the seller of the horse says, yeah, it's got no problems, it's an excellent horse. Subsequently, it turned out that the horse was lame, that there were problems with the horse. So the purchaser of the horse sued the vendor for breach of contract. And essentially, the promise that was made, if a promise was made at all, that the horse was in good condition, that promise was made after the contract was made. So there was no good consideration for that promise. And any consideration that was given was past consideration. It wasn't given in exchange for the promise that the horse was good. It was given in exchange for the horse. So the £30, 30 quid that was spent on that horse was spent or past consideration. Questions, concerns? That's the classic case. So there are, however, exceptions to it. So a good example here is Lampley and Braithwaite. So Lampley and Braithwaite involved two, it's a very old case, can you see, 1616. One of these fellows, can't remember which, that's why I need my notes, was accused of murdering somebody. And his mate, they were both quite high-born fellows, asked him to go around the countryside seeking witnesses and getting help so that he could do better in the case, basically, when it came. This gentleman ran around the country doing all of these things, staying at inns and getting horses watered, and came back, told his mate what he'd done, and his mate said, yeah, we'll pay you £100. His mate then subsequently dies in prison. He goes to the estate for the 100 quid, and the family's members say, no, you can't have it, no contract, because you did all of those things before you agreed a price. So the price wasn't agreed in exchange for good consideration. In order to be good consideration, it needs to be sufficient. And the court said, well, actually, let's think about this here. These things were done at the request of the promisor, and there was no expectation that they were done gratuitously. They were done as in a commercial relationship. So it comes back then again to intention. See how each of these elements are linked to each other in some way? So at the time that the request was made, the circumstances implied that payment would be made. So they found that there was a contract, and so this exception, this set of rules, that there is an intention that there be a binding contract first, and secondly, that the things are done at the request of the promisor, is an exception to the past consideration is not good consideration rule. Sorry, sipping my hot water there. More modern version of this same set of finding is IPEX software and Hosking. So IPEX software is another, it's a Victorian case from memory, where basically one of the owners of a software company that was going to be sold to the IPEX group got involved in helping out the vendors the purchasers along the way. So was basically negotiating with the other owners, getting information, doing a whole lot of things. And the evidence showed, and evidence is really important in cases like this, that there was an understanding that he would benefit from the sale in the form of getting shares in the reconstituted entity. A contract was drawn up that actually even said that. It allocated, from memory, I think even the slide says 5% of the newly formed entity was allocated to him. Subsequently, IPEX said, oh no, we don't have to give you that because all the things that you did before we signed that agreement. So there was no agreement until that arrangement was made, and so your consideration was past consideration. And the court said, well, that's not fair. All the evidence shows that there was an agreement in place, even if it hadn't actually been quantified at that stage. Nobody thought that it was a gratuitous promise. And basically he was performing a service on the basis that it would be paid for at some future time. So in this case, they found that this, like Lampley and Braithwaite, was an example of an exception to the past consideration rule. So another way that we have, that we need, or another exception or way of thinking about consideration is that performing an existing legal duty will never be sufficient consideration as far as the law is concerned. So that basically comes down to two different kinds. I'm going to spend more time on the second, but an existing legal duty can arise from a public duty. So showing up, the police showing up when they're caught, because that's what they're supposed to do, showing up for jury duty when you've been, or showing up when you've been summoned. All of these are things that you are required to do under law. So claiming them as consideration for something else is not sufficient consideration. And then the second half of this is pre-existing contracts with someone else. So when you have an arrangement that's already in place and then something happens that you want to vary it or change it in some way. So like Roscola and Thomas, where the purchaser subsequently asked about the condition of the horse, and so the question became whether there was consideration for the promise about the condition of the horse. But so that's your general exemption. It's an existing legal duty or it's past consideration, one or the other, depending on how it works. So what are the exceptions to that particular rule? Please stop me with questions as you go. Just unmute and yell out. Or actually, in a design thinking class that I ran on the weekend, people were holding up post-it notes and doing that. It does actually catch my eye quite well. Or just wave your hand around. And saying that, I'm just going to move that so I can see more of you. Or not, depending on how it works. There we go.
Kath, I have a question. It
Great.
relates to the assignments. I'm not sure if we can ask it here. To what
Is this
extent can we...
yeah, sorry, is it related to what we're talking about right now?
Yes.
Great, good.
Yeah. So to what extent can we use the exceptions to the legal duty rule to argue, but you should stick to this? Because it feels a bit funny to use a case where the judges held, oh no, this is the exception, to argue, but in most cases, including this one, it wouldn't work.
Yeah, look, it is, I get it that does feel odd, but it's often the cases that have been appealed and appealed and appealed, so they've got quite a high level of precedential value, are the ones where they're sitting on the edges, and they're the ones that give us the most information about how the real rule works. So it may in fact be obiter when you're using a judge's description of what the rule is, if in fact the decision was the rule doesn't apply in this particular circumstance. But if you can so if you're saying a rule applies, then you might need to distinguish the facts from the case that you got the information and say, well, the rule didn't apply in this one because of A, B and C, but in this case we don't have A, B and C, we have D, E and F.
Yeah, and past consideration, that is the case that, like, after Roscola and Thomas, all the other cases just seem to deal with exception.
Yes. Yeah, you're pretty much right. Absolutely.
Yeah.
So, and then there's some odd ones that sort of come out where they go quite hard line, but they tend to be quite low in the pecking order. So what will happen is and it makes sense that it's actually the ones where we're really refining exactly what the boundaries of the rules are the ones that get appealed over and over again when you think about it. Good question. Thanks, Tiffany. Okay, so let's just have a look at some of these. Well, just quickly, performance of a public duty. I've only got one slide for you in relation to this. Collins and Godfrey is a key case, 1831. You can see this is not a controversial issue. Attendance at court as a witness under a subpoena will not be sufficient consideration for a promise of payment for a witness expense. If you get a subpoena, you have to show up. However, and again, here's an exception for you, acts that are done above and beyond your public duty could be sufficient. So Glassbrook Brothers and Glamorgan County Council, so that was, this is actually 1950s coal strike in England. In fact, that picture behind, I was looking for a picture of the 1950s strike today to put on the slide and I couldn't find one. So these were before the big coal mining strikes in the 80s under Thatcher, but kind of similar sort of thing. There's massive coal strike in this particular town. And so there was a picket line around the mine site. And the owners of the mine organised for the Glamorgan County Council to bring additional police to patrol the line to let people who weren't on strike come into work. And initially the police were very reluctant to do that. I think there's evidence in the case that they were pretty much on the side of the miners, but it was such an extreme set of circumstances that the mining company offered to pay for additional police to arrive. So they did that. They sent extra police. They then sued later in contract because the mining company, surprise, surprise, didn't want to pay them. Now, the mining company said it was a tense and volatile situation. You have a duty as the police to provide police in those circumstances, and you didn't do so. But ultimately, the court found that, in fact, at the request of the promissor, so this is the promissor of the additional funds, they provided more police than they were required to under the law. So they did something above and beyond. So there was consideration for that extra bit. Performing the public duty of providing baseline police, they couldn't charge for that, but they could charge for doing something additional. Okay? I said I had one slide, but it turned out I had two. So let's spend the rest of this time talking about existing legal duties that are promises to third parties. Now, in the slide, I think I've got 5 different bits. We're going to look at each of them or examples of each of them as we go, but they all kind of fall under this general ambit of where you've got a promise to a third party that for some reason or another you need to change, or that you're making an additional promise. So the one that can be the most difficult to understand is absolutely one of the oldest. So this 1602 decision is the rule in Pinnell's case. So it provides the general rule that part payment of an existing debt can never be a good consideration for a promise to waive the whole of or the remainder of the debt. Now that can be a little bit confusing, particularly if you haven't been in this situation, but and commercially this kind of thing happens all the time. Say I owe you $1,000 and I've owed it to you for a really long time. And you keep asking me to pay it, and I keep saying, look, I just can't. I can't pay. I haven't got the money. So instead you say, well, how about, and it's due now, right? I am right now in breach of contract. So you have the ability to sue me, and I'm just like, my back's against the wall. I just can't pay you. I'm not going to pay you. Do what you have to do. And so, but I have some indication that I have some money. So you say, how about we agree to $800 instead, and you'll pay it in 4 installments. So effectively what you are doing is agreeing to waive the $200, the amount that is owing to me. Now if I pay you those 4 installments, there's actually nothing. The Rule and Pinnell's case says you can sue me for the balance, even though you've promised me that you won't if I pay in installments. So now again, kind of seems fair if we think about the way that consideration works, but it's also commercially a very difficult situation, because I could be in this position, well, I can work really hard to stop you from suing me and pay you $800, or I could put that $800 into some other aspect of my business to try and get myself up and running again. I can make commercial decisions about this. And if you sue me now, it's going to be 3 or 4 years before we get to court, so I can hold that off. Sierra, unmute, Dal. Sorry, I shouldn't call you Dal, should I? That's habit.
It's me, or is the audio is cutting in and out?
Is it?
Yeah.
Oh no. Okay, I'll try and stand closer to my computer and see if that helps.
It was fine before, Kath. It seems to have deteriorated.
I'm sorry. I don't think there's very much I can do about it, other
It's
than.
fine now.
Well, I'll try and stand still in front of the computer and hope for the best. Thank you. So,
Slide again.
sorry, what was that, Holly?
You'll be able to just go back over like what you were saying in the last 2 minutes, because I didn't really catch.
Okay. And look, this is an important point. So I'm sorry for those of you who did catch it. I just want to make sure that you really understand this. So, the Rule in Pinnell's case says that if you, that part payment of an amount that's already owing can never be consideration for a promise to waive all or part of the remaining debt. So the example that I was using is if I owe you $1,000 and it's due and payable now, you can sue me for it right now. And I will lose, but I am just refusing to pay it. I don't have the money. You're going to send me bankrupt if I pay that. I just am not going to pay it. I would rather not pay it. So you might, and this is quite a commercial tactic that some people will use, it's just like, well, I can't pay everybody, so I'm just not going to pay you. And you might say, well, how about instead of you paying me $1,000 immediately, we'll reduce the debt down to $800 and you'll pay it in installments. Now that's great. I then say, okay, I can manage that. I'll pay you $200 for a week for the next 4 weeks, and then I'll get you off my back. You're not going to be calling me and debt collecting anymore, and you're not going to sue me. And at the end of those 4 weeks, you could then come to me, because the Rule in Pinnell's case says this. You could come to me and say, I want the balance of that $1,000 that you owe me. And I would be saying, now hang on a minute, you promised me that you wouldn't sue for the balance of the amount. And in reliance on that promise, I did something I wasn't going to do. I paid the debt. The Rule in Pinnell's case says that my payment of an amount I already owed you, the part payment of an amount I already owed you, can never be good consideration for your promise to reduce the debt, unless fresh consideration is provided. That's why I've got the picture of the peppercorns there, is to remind you that it doesn't have to be adequate consideration, it just needs to be legally sufficient. So for it to be fresh consideration that works, a clever deal would have gone like that. I would have been saying, I can't pay you that $1,000, I'm not going to pay it, sue me if you want to, it'll be 3 years before we get to court, and then maybe I'll be back on my feet, but I might still be just as broke as I am now. And you could say, how about we reduce the debt to $800? $800 is worth more to me than nothing. You can pay it in these instalments, but you must also give me that half-drunk bottle of wine in your study. Now, if I were to pay you some consideration for your promise...
Yeah, okay. Sorry to break in.
Yeah, go on.
The audio is basically not possible to hear.
Oh dear. And I'm doing dramatic actions with wine bottles as well. Okay, what do we do?
I'm not sure. It sounds like a bandwidth issue somehow.
When you go to questions, it's fine.
Okay, maybe. Can I stop sharing my screen? That seems to help a great
And
deal.
then we could bring up we could download the PowerPoints ourselves.
Would you mind? And I'll look. The screen. If you can do that, I think that will help. Just give me a second.
Yeah, see, now it's fine.
Okay, awesome. Okay, shall I start with Pinel's rule again?
Yes.
Yes.
I'm sorry.
No, don't be sorry. Look, I really appreciate this, and the recording will have the slides in it, okay? I just...
It might be, if you've got the door shut and it's a Wi-Fi connection...
No, I've got a hardline connection.
Yeah, no worries.
No, and it comes from my room. When I shut the door, they get cross with me. Okay. Now, Pinel's case is important, so I'm going to try one more time, okay? So the way the rule works, just on a straight reading of the rule, is it can never be sufficient consideration as a matter of law for a promise to waive part of a debt. Sorry, I'm just trying to get this into a grammatically correct sentence. A promise to pay part of a debt can never be good consideration for a corresponding promise to waive the balance of the debt. So the example that I was trying to work through is, you owe me $1,000. I don't want to pay it. You're debt collecting away. I don't have $1,000. At the end of the day, you can sue me. It'll be 3 years before we get into court, and I don't care. Like, it's just, I gotta pay somebody, but it's just not going to be you. So you say to me, okay, instead of you paying me $1,000, I'll agree to $800 as long as you pay it by next Wednesday. I then pay the $800 by next Wednesday. The rule says you can still sue me for the balance. So you could then bring an action to sue me for the $200. I would be then saying, hang on a minute, that is completely unfair. I acted in reliance on your agreement to waive the balance of the debt and made that payment. Now I'm just as badly off I'm worse off than I would have been before. But the law is really clear. But there is actually a way around this. And it's also, I think it illustrates what fresh consideration is. And that's why I've got the picture of the peppercorns on the slide that you can't see. Because in order to create fresh consideration, it doesn't need to be adequate, it just needs to be legally sufficient. So the example I was giving, you could say, okay, I will agree to waive the balance of the, well, in fact, I would have to do it, because why would you want consideration there? Because you want to get all of your $1,000, right? If I were clever, I would be saying, I will agree to pay all of that money by next Wednesday, and I will then also give you this half-drunk bottle of wine that was in the church yesterday, in exchange for your promise to waive the balance of the debt. So we think about it, there's kind of two contracts here. The first contract is whatever the contract was that meant I owed you $1,000 in the first place. I'm in breach of that contract until I pay the money. It's already owing. Then there's a second contract, which is your promise to agree to waive the balance of the amount that I owe you. And my consideration for that would have been the payment of the bottle of wine. Okay? It's actually, once you get it in your head, it'll make sense to you, but sometimes it's actually kind of a bit crazy. So, now there are some exceptions, of course, there are exceptions to the exceptions. So Folks and Beer is probably the best example. It's really hard, you won't actually ever be able to see the decision in Pinnell's case. It's actually quoted in Folks and Beer. The original case is so old that it was decided in Latin. I guess the point I wanted to make in relation to that is ultimately it was held that the payment of a lesser sum in satisfaction of the obligation to pay a larger sum can never be satisfaction of the whole. So it's enforcing Pinnell's case rule, embedding it into the common law. But the decision of Lord Blackburn is worth having a look at because he does talk about how commercially this kind of stuff happens all the time. And seeing you can't see it, I'll quote, Lord Blackburn commented that the rule is not necessarily commercially sensible because many businesses would regard the prompt payment of only part of a debt as more valuable than insisting on their rights and enforcing payment of the whole. And there's a typo on that slide too. I hate it when I see them. Exception to this, a promise to a third party. So the case here is Hirachand, Parmachand and Temple. It's an interesting case because I find it quite inconsistent with the way Pinnell's case works in a number of ways. And, well, you decide for yourself. I actually think it probably is a product of its time, 1911, and I think it's probably, dare I say, racially motivated, possibly. I just think if the parties were the other way around, we might have got a different result. So there was a Mr. Temple who was on an adventure in India, and he borrowed some money from a moneylender, and he didn't pay it back. And the moneylender, Hirachand Parmachand, basically was suing him for the amount that was owing. There was no dispute that the amount was owing. So Mr. Temple's father, Lord Muckety Muck, wrote to Hirachand Parmachand and said, I've enclosed a cheque for whatever it was, representing a lesser amount than the full debt. If you bank it, I will treat that as your acceptance of this amount in full and final settlement. So the moneylender did what any moneylender would do, although you as young lawyers will probably think twice about accepting settlements on these terms as a consequence of your understanding of how the law works now. Banked the cheque and then continued to sue for the balance. He banked the cheque because that was part payment of what he was owed, and it's a well-known premise of the common law that payment of a lesser sum can never be good consideration for any agreement to reduce the larger sum. But the court said, no, actually, it would be a fraud on a third party if you didn't keep the promise that you made to Mr. Temple's father, if you didn't reduce the amount of money or the debt that's owed by Mr. Temple himself. So we have an exception. Yeah, I do wonder if Mr. Parmachand had borrowed the money and Lord Muckety Muck was trying to recover it, whether or not we would have got the same result, because I can see this idea in equity of the fraud on the third party, but it is so inconsistent with the other decisions. But it's become a well-established exception from that rule. I hope my dog doesn't see your cat, Marius. Holly,
Would you be able to explain, in the textbook they also said that one of the exceptions is a composition?
A composition for creditors.
Yeah.
So that's where you actually have a court order coming out of a liquidation or a winding up or the appointment of a receiver or some other third party coming in that that basically where all of the creditors get together and agree that they will take X cents on the dollar. Either, sometimes it's part of a winding up, but these days as part of an administration where a company that's fallen on tough financial times is trying to trade out. So when there's a court order or there's a composition where all creditors are involved, where it's not just one creditor basically being defrauded or potentially defrauded, that's the end result. This is the sort of thing that happened with ATCO Controls and Neutronics. So ATCO is the parent company of Neutronics, and they were part of the same corporate group, but they have different legal personalities. So the parent company loaned the subsidiary company money. The subsidiary company was having difficulties, trading in difficulty, and so the parent company, effectively they agreed with the parent company. They had the same directors, the same management, etc. This is a case that you might look at in company law as well. But they basically agreed that the subsidiary wouldn't have to continue paying the debts while it was trading in difficulty, as long as it kept trading. Subsequently, a liquidator was appointed to the parent company, and so the liquidator is trying to recover the amounts that were owed by the subsidiary company. And the subsidiary company says, well, our parent company promised us that we didn't have to pay it as long as we kept trading. And basically, the Court of Appeal rejected that argument. He said they found that there wasn't sufficient evidence that there really was any fresh consideration, that there was a quid pro quo. And again, like woolen mills, continuing to trade is what you want subsidiaries to do. They should just be continuing to trade anyway. But again, it's an example of the Pinnell's case rule working without any real dispute in an Australian context. Pao On and Lao Yu Long, quite a complex set of facts. Might have done your head in a little bit, particularly as I can see Tiffany's head's ready to come off, I think. Particularly as you won't be used to the corporations laws elements of it as well. But ultimately, we include this case because it is an example where something is done at the request of the promisor, where there was an understanding that the act would be remunerated, and the promise occurred in advance. If the promise had actually occurred in advance, then it would have definitely been enforceable. So it's basically a really complicated version of Lampley and Braithwaite, when you think about it. So a subsequent promise was seen as merely acknowledging indebtedness and defining the amount of compensation. It's one of those examples where the court is really seeing that commercially we don't always have this neat offer matched with acceptance, consideration, all of the elements all at one time. It kind of negotiated and evolved over time. And any of you who end up as commercial lawyers, you just see this all the time. Are you shaking your head, Tiffany, because you just think it's an appalling way for people to run their businesses, or?
Oh no, the idea of being a commercial lawyer.
I tried very hard to get some of you over onto the dark side. It really is quite a lot of fun when we play, believe it or not. I extracted in the slides the bit that I think Lord Justice Scarman's decision, and I've highlighted what I think is most important. The benefit of the contractual obligation to the defendant is that if the plaintiffs breached the main agreement, they could have been sued in breach. Ordinarily, only Food Chip could have sued for a breach of the main agreement. So it was this, the complexity of the arrangements meant that it was very clear that it was never a gratuitous promise. That in fact we had a party that kept vacillating as to what it is that they would and they wouldn't agree to do. So a promise can form a pre-existing contractual obligation to a third party, and that promise to the third party can be valid consideration because the promisee obtains the benefit of a direct obligation. So again, reminiscent of Temple and Hirachand Permachand, the other way around, actually it was Hirachand Permachand and Temple, where because we have this third party, it creates a new set of obligations, and that there could be a fraud or there's a breach of that third party contract if you don't follow through with the contract that you have with the original party. So often the best way to look at this question is whether or not there is fresh consideration. So Wigan and Edwards is the key case here. So Justice Mason, so this is the 1973 case, so relatively recent for us. The general rule is that a promise to perform an existing legal duty is no consideration, at least when the promise is made by a party to a pre-existing contract, when it is made to the promisee under that contract, and it is to do no more than the promisor is bound to do under that contract. I actually think the best way to understand this is what the textbook has done, where it looks at Stilk and Myrick and Hartley and Ponsonby and compares the two, because you've got two cases with very, very similar facts other than for a key point, the number or the volume of sailors, and very different results. But that's because the law is applied in exactly the same way. So, so those cases, I'm going to have... Yes, I think the first one is Stilk and Myrick. So basically what happens, sailors get on a boat, they go to CCC to see what they can CCC, they travel halfway across the world, there's a mutiny or an accident or something happens, and a couple of the sailors are injured and aren't returning. So the captain says to the others, it's going to be, we need to get back. I'll split their wages between the rest of you when we get home, because they won't be claiming them. They get home, shipping company refuses to split the wages, the sailors sue, and the court says, you had an existing legal duty. You had a contract to sail out to CCC and to return. And you just had to perform your contract. So this additional amount of money that was promised to you when you were halfway around the world, there's no consideration for that. That's an additional amount of money. So then, I really hope I'm getting the order of these cases right. In Hartley and Ponsonby, the same thing happened. Group of sailors enter into contract, they sail out to CCC, halfway across the world, somebody gets injured, somebody gets sick, there's a mutiny, and almost, if not more than, half the crew are not returning. The other sailors say, no, this is dangerous. This is going to be way too much work for us. We would rather, we'd rather take our chances in America and find out what happens when Trump is finally elected, than sail back to you, with you. And the ship's captain says, well, with these other sailors gone, I can effectively double your wages. We've got half the sailors and I can double your wages if you come back. They're like, okay, well, we'll take that risk then. They get back. What do you know? They don't get paid. So very similar facts except for the volume. They then sue. The ship company says, but we've got this authority, Stilk and Myrick, almost exactly the same facts, and they didn't have to pay. And the court says, well, no, because there was something more than their existing legal duty. Their duty was to sail on a fully staffed, is that what you call it? Fully crewed ship. And sure, you can expect to lose one or two people along the way, but when half of the sailors have disappeared, it's effectively a much more difficult, much more dangerous, and much more strenuous job. So there is actually additional consideration for the additional money. Okay, so I actually think thinking about those cases really helps you understand, or helps me understand this point. So compromise, which is actually, I think Holly raised just a minute ago, falls into this idea, how do you tell whether it's a compromise, sort of an agreement to change the price that is supported by fresh consideration, or it's just a forbearance to sue of the type that would fall under the rule in Pinnell's case. And really, so again, Wigan and Edwards is the case that you need to have a look at, and the question becomes whether there's an honest belief that the contract had in fact a term or understanding that there would be an entitlement to refuse to perform. So if you believed under the contract that you had that right, and it's a genuinely held right, there, and you can refuse to perform, then compromising, coming to some other arrangement, isn't a real bona fide settlement of your dispute. And so then the payment that you make is in settlement of the dispute, as opposed to a renegotiation without consideration. So, I have a slide here which I was going to get you to talk about, which I'm hoping you can see. So, it kind of seems straightforward until you try and apply it in a real life situation. So I want to talk a little bit about the last exception, which is the practical benefit exception. So this comes up in the kind of circumstance I've got on my ridiculous slide where I'm talking about, so if Darth Vader, for example, agreed to build a Death Star in exchange for $500, and that he made this agreement with the Empire. And partway through building, Vader realizes that it's going to cost more than $500 to build an interplanetary weapon. And so he tells the Empire that he can't actually finish this task unless they agree to pay him $600. So the Empire will agree to that because they need their interplanetary weapon completed. And he finishes his planet-sized bomb. But the Empire would then renege on the promise to pay the $600, instead paying the original price. What are the kind of issues that come out of that kind of scenario? Other than I've outed myself as a Star Wars tragic. So just think about that. I want to talk about the practical benefit exemption as it shows up in two cases. So we start with the UK case, which is Williams and Roffey, which is a 1990 case. So Roffey Brothers was a builder-developer, and it had a contract to build some flats or to restore some flats. And it would get a incentive payment if it got things done by a certain time. So, actually, no, it wasn't an incentive payment. It's the opposite. If it didn't have work finished by a certain amount of time, it would be paid less by the head contractor. So it subcontracted out carpentry work, and Williams was the carpenter who took up that work. Williams then fell into some financial difficulties, and so Roffey said that they would pay an extra £575 for each of the units that they finished on time, because Williams at that stage was ready to just walk away from the contract. Now, again, at this stage, it's important to remember that it is not a crime to breach a contract. There are certain things in business that it is a crime to do, like not pay your tax, not pay employees on time, or to pay their withholding taxes or their workers' compensation. So Williams is there, he's got financial difficulties. He needs to pay his employees, he needs to make sure he's paid his tax and done all of those things. He's making a risk assessment. And from his point of view, it is less risky to just breach the contract, to walk away with the unfinished work and not get paid for that job, than it is to not be able to pay employees or pay his tax or do those other things. And Roffey Brothers at the same time is also making a risk assessment. They're thinking, well, at this late stage, getting somebody else in to do it at that price is going to be more difficult than paying an extra amount of money to get this job finished. So that's the arrangement that they've reached. But, of course, my guess is whoever the Roffey Brothers directors were around a barbecue somewhere with a law student who said, well, hang on a minute, a Pinnell's rule, a subsequent agreement to change, or, past consideration, a subsequent agreement to change without any consideration is not good consideration. It's not sufficient consideration. So there's no basis on which in contract you have to pay that extra 575 quid. So, as these things do, and this is how we find out about them, they go to court. And the court held that there was a practical benefit to the Roffeys in agreeing to pay the additional amount. And as a consequence of the existence of that practical benefit, an exception to the consideration rule applies. Now this again it's subtle, but it's important. They did not find that the practical benefit was fresh consideration. Rather, they found that the practical benefit was the existence of the practical benefit was an exception to the requirement for consideration in the first place. So in Musumeci, we basically have pretty similar facts in a way, well, different, same. So the Musumeci's owned a fruit and veggie shop in a shopping centre, and they were the only fruit and veg shop there. And then at some point, the owners of the shopping centre leased one or more of the shops to a different fruit and veg vendor. It might have even been to a Coles or a Woolworths or something, can't remember. But as a consequence, the Musumeci's could see their business reducing. So they threatened to leave, to breach their tenancy and leave early. Again, they're making a risk assessment. It's not great to breach a tenancy, and yes, we will probably get sued for that. But again, that's 3 or 4 years in the future. But right now, with this declining market and the rent so high, I'm at risk of not paying my staff or not meeting my other obligations. I am better off walking away from this at this stage. And the shopping centre said, no, don't do that. We will reduce your rent until we work out what's going on. Actually, as it turned out, the Musumeci's did okay. And over a couple of years later, the landlords came back and said, no, we want full rent and we'd like the back pay for the other periods of time as well, because actually you did okay. And the court actually had a look at Williams and Roffey and said, well, yeah, this is a principle, this practical benefit principle is something we will adopt in Australia, but we're going to incorporate a test. So we're going to need to see that there was, I hate it when I don't have my notes in front of me, that there's a test, just too difficult, and it's just going to annoy me now because I can't remember off the top of my head exactly what the requirements of the tests were. Any of you got it in front of you? Want to share? What did Justice Santow say? Beyond, there was a practical benefit in not having empty shops. Well, you can give me a second to find it myself.
So, what it says is part payment. I don't think we've got what the actual justice said on our slide. Oh, sorry. Practical benefit of maintaining a fully let shopping centre, and the beneficiary's performance must be worth more than any remedy against the beneficiary.
Yeah, it's that, sorry, I've got it in front of, I do have it in front of me, but I had, now the dogs are running around crazily. Somebody must be feeding them. It's that addition in the test of it has to be, with a practical benefit, it must be worth more than the remedy against the beneficiary. So that's the test part that the Australians have added. Sorry, I lost my nerve there for a second. So it can't just be any practical benefit. It needs to be on balance, that the benefit that you get, not having an empty store, not having to sue somebody for the rent, must be greater than the remedy that you would have got. So all they would have got, so sorry, I can see your face there, Murray. It is great when I see faces because it does really help me work out whether I'm making any sense or not. But let's say that the amount of rent they were forgoing was $1,000 a year. But if that shop was empty, that's going to dark shopping centres with empty shops. It's very hard to get tenants in them at good rent. So they might have gone for, if they'd lost their $1,000 a year is one amount, but they might have actually had an empty shop for 6 months and other rents would have gone down as well. So we might be able to quantify that loss at $5,000. And so on that basis, the practical benefit, not losing $5,000, was worth more than the amount that they agreed to reduce the rent by. Make sense? So 2 more slides and then we'll be pretty much at an hour in about 90 seconds. And then we're going to stretch, I'm going to swap some stuff over and we're going to do a couple of exercises. So couple of slides here just back to back. The first one is the exceptions to the rules in Pinnell's case, and then the next one is about the existing legal duty rule. What's important there is that ultimately if you go to the slide at the end that shows how the whole picture works, the bits that are in orange are the general maxims that help us understand what consideration is and what will be sufficient consideration. So consideration needs to move from the promisee, but it doesn't necessarily need to move to the promisor. So Lampley and Braithwaite is an example. No, it isn't. Pumachan and Taylor is an example there where essentially there was this promise to a third party, but it needed to move from the promisor. That's what the court found anyway. I think it's a bit dubious personally. Consideration need not be adequate, but it must be sufficient. We spoke about that mostly last week, but you can see examples along the way here. So even the rule in Pinnell's case, it doesn't have to be something adequate, but if you add in something in exchange for the promise that somebody else gives you to reduce an already owing an amount, then we will have fresh consideration, but it doesn't need to be equal in value. Key case for working out the reasons why we don't do that, why we don't look at adequacy, is Kirby's decision in Woolworths and Kelly. Past consideration is not good consideration. The rule is really clear in Roscola. Part payment of a debt is not good consideration. We've spoken about that ad nauseum. I've actually explained that 3 times. Those of you on the recording, it'll be really interested to know if any of them were better or worse than the other explanations. And then performance of an existing legal duty is not good consideration. And again, when you think about it, Pinnell's case is actually another way of looking at that. Because you have, if you owe somebody an amount of money, you have an existing legal obligation to that person. And then we have the exceptions. And the exceptions to, if it is a true exception, like the practical benefit exception, we're not actually finding fresh consideration and a new contract. There is actually an exception to the requirement for consideration at all for that promise. So, I'd like to change some things around. Can everybody get a drink of water? Can you stretch? Do I need to put on music? We're just going to have a 5-minute break.